The third principle for me is a really key one. Write it down and keep it. So what do I mean when I say write it down? Well, there's several things you can write down. So for example, if I have a phone conversation with somebody, I record the date, the time, and the details of that conversation, particularly if it's in a business context. If it's in a personal context, there's no necessarily a need. But in a business context, you want to have those written down. Why? Because it forms a contemporaneous note. And if there is litigation later, then you have a record of what was said and the details that you thought at the time. The second principle then is, once you've had that conversation, sending an email to that person to confirm your understanding. Why is that? Well, because that's to get the detail and the understanding to make sure that you and I are thinking about the same thing. You can avoid a lot of issues when you are very clear about what it is that both parties expect. Write it down is really important. Getting an agreement in writing is even more important. But tell me this, how many people think that an agreement is only legally binding if it's in writing? No, right, absolutely. It is always legally binding if it's an oral contract. It just needs to have certain things there. So why do we say get it in writing? Anyone?
Easier to prove.
Easier to prove. Evidence, that's exactly right. Anyone else?
You've got the detail there verbatim as well. So.
Yeah. And you can prove that both parties have signed up to the same thing. So for me, it's always a matter of evidence. What has that party actually said? What did I say? What did you say? It's all in that agreement. What's really important in writing an agreement, what will always be, and I suggest that you look for it in an agreement, is a sentence that states that any other discussion between the parties is not counted as part, so that everything in that agreement is part of the agreement. And just having a look for that one statement, particularly if you're diligent with the agreements that you're putting together, that'll be really helpful later on if they say, yeah, but wait a minute, I've got an email that said you do this, this, and this. No. This agreement is the agreement, and that is what the entirety of the agreement is. So that's really important, writing it down. I would also say keep all emails. How many people don't keep emails? How many people throw them away? Particularly in a relationship where you're in negotiations with parties, keeping those agreements are evidence of what was intended if you don't end up signing an agreement. But for example, you might start doing some services. You might say, oh, no, don't worry, we'll sign it later, which I can guarantee this is one of the biggest things that I would see with small businesses, and that is they go, oh yeah, we've got an agreement. Have we got a signed version? No. And the signed version gets to show that will show the details, or that will, if you don't have a signed version, then the emails will give a good indication about what is actually agreed. Yes.
Could you use a verbal agreement? What's an example of a verbal agreement being binding? I agree with your partner, or?
Sure. Now, the question is, does that have enough detail in it? So if we shake hands and then I start working from your offices, have we got an agreement? Potentially. And this is where you need evidence, and you show, therefore, that you've got an agreement and that both parties have agreed to it. What you don't want, I had an example last week, and by the way, whenever I tell a story about any clients, know that I have, I'm not breaching any confidentiality. I will twist the facts somewhat so that you know I'm not just suddenly throwing out stories. But one of my clients, for example, had an agreement that said it was non-binding. But one of those parties, even though it said it was non-binding, it had enough detail in it, and one of the parties had given money, as it said they would in the agreement, and therefore there was an argument. Is it actually legally binding? Maybe. Do you want to argue that in court? Probably not. So from your perspective and from your side, making sure that you have everything tied up and you've got all those loose ends together is really important. And writing it down and keeping it is the key. Making sure that your records are amazing. Tell me this, how many of you guys know what your exit will look like? Do you know what in the future you might want to do? Do you want to sell, buy, list your company? Anyone? You know. Okay, so there's a few people that know. We'll come to exit in a minute because an exit strategy, exactly. Everybody should have an exit strategy because you are going to exit your business at some point. The reality is it might not be intentional, but you are going to exit your business at some point. So if you have an intentional exit strategy or unintentional exit strategy, that will be, we'll talk about in a minute. However, what you want to make sure that you have is documents in place so that if you choose to sell your business, you've got everything written down and you've kept them. That will save you so much time, money, and energy later on, especially if you've got a good document storage system online. If someone comes to buy your company or if somebody wants to invest in your company, you can give them the login details and say, here you go, here are all my details. And that is honestly so much of a time saver and an energy saver.